I want to welcome back our viewing audience for a continuation of the discussion held between myself and Marcus Klebe, my law firm colleague, on the subject of due diligence in the merger and acquisition process. Welcome back, Marcus.
Thank you, George.
Let's assume we've worked our way through the bargaining process and we've gotten to the point where we are documenting the agreement that's been reached in what we would call a definitive agreement. Do the facts that we have developed over the course of the diligence play a role in the actual documenting of the definitive agreement? How does that work?
The purchase agreement is going to be based on the realities of the company and the facts and circumstances as evidenced by all the due diligence, by all the documents that you've produced in all the different areas. And there's a very particular section of the purchase agreement that's implicated, and it's called the representations and warranties section. And in almost every single merger deal, certainly with any moderately sophisticated buyer, the buyer is going to ask that the seller make a series of representations and warranties. And another way to think of these are that they are promises and statements of fact as about the business. So you will make a statement that is, as of year end, we had $30 million of annual revenue. That is a statement. You are going to have to provide the financial information that backs up that assertion. And if it ends up being incorrect, then the buyer is going to say that he needs to be made whole for that breach, that essentially you've promised something and you haven't delivered. Or if you say all of the receivables are going to be collectible and you have 35 million of receivables and then you only collect 30 after the buyer closes, the buyer may make the argument, well, you promised me there'd be 35 million of receivables and yet I've only managed to collect 30.
Marcus, we've talked about the use of this diligence and the facts and documents that we generate during the course of the diligence in the documenting of the definitive agreement. How do we use that information to narrow the scope of the reps and warranties and the risks that they represent to the seller?
In the purchase agreement, there are really two opportunities to limit the reps and warranties. The very first option is to not make a representation or to add a qualifier to it, and you say something like, to the best of our knowledge, the following is true. In many cases, the buyer is going to press hard, and especially in areas of financial or other hard data and material contracts, they're not going to permit you to kind of shorten the scope of or to provide a qualifier in that way. So then we go to our fallback position, and this is where the diligence becomes really critical. And that is, you need to carve out the exceptions to the reps and warranties. So the idea here is that after you've made a statement, and I'm going to give one of the most common examples that's going to be readily understandable, and that's a rep and warranty about litigation. And you would say, in the purchase agreement, there is no litigation pending or actual with respect to the business except that which has been disclosed. So at that point, we have hopefully done all of our diligence in a way that we have actually summarized all of the active and pending litigation. So for example, if an employee has been unfairly terminated or alleged that, and there was a settlement, if there was a product liability claim, it doesn't matter as long as it touches on the business and you've revealed it. What you are saying to the buyer is, yes, you buyer have agreed to pay me the negotiated purchase price, and I'm promising you and I'm telling you there is no litigation except for, as what's on the schedule, the actual litigation or threatened litigation that I have revealed to you. And as a result, it doesn't matter whether that litigation ends up being a lot more costly for the company after the buyer buys it. You've basically put him on notice, and you have revealed the facts, and the buyer has nonetheless decided to go forward with the transaction. So in that way, by being very upfront, the actual questions that you're answering, all of the data that you've compiled, will lead to the exceptions for all of the reps and warranties. So you will say in the financial area, all of the receivables are collectible, except we generally have 5% that are not collectible, so we're going to agree that if the non-collectible receivables don't exceed 5%, then the buyer can't come after the seller. It's that kind of honest give and take and revealing of the data that will pave the way to, again, the building of trust, an agreement in which even though the buyer has paid the higher price and the seller has preserved the value, you also don't have the really high substantial risk of a clawback or a post-closing claim by the buyer that you have breached one of these reps and warranties, and that after the closing they're going to be able to claw back some of that money for you.
Now, we have what we call survival periods in our definitive agreement. Those survival periods are the period of time, whether it's a year, 2 years, 18 months, or something of that sort, during which the validity and the truth of the reps and warranties is determined. At the end of that period, then the buyer, if it finds that any of these reps and warranties are in fact false, has the right to make a claim. So what we are trying to do here is to narrow the bases upon which those claims can be made, and thereby permit the seller to keep as much of that money that it was paid at the outset as possible.
I think I have just a concluding thought that I think will hopefully tie everything together, which is that rarely is anything gained by playing hide and seek with the buyer. The seller, when we really urge our clients to not be an ostrich, to not put their head in the sand, but to honestly assess the strengths and weaknesses of their company, to do a due diligence undertaking if they have any intention of selling their company, the time to prepare the company for sale and to understand where your documentation strengths and weaknesses lie, what information you have and what you need to gather is really now. And I would urge again to check on our website the due diligence checklist that we have, and to come and talk to us about the ways that you can prepare your company for sale.
Marcus, thank you for your time and talking about this important subject. I want to thank our viewing audience for joining us today. For more information on this important topic of mergers and acquisitions, please visit our website at www.gpsinc.com. Thank you for your attention.